Hello and welcome to our webinar on speed and consumption claims. We're going to talk about a number of areas today, and you should be able to see on a slide coming up soon what we are going to talk about today. We are going to be covering a series of questions because a claim often begins with a deduction from hire by the charterers. And you'll often find they produce a voyage analysis report prepared by a commercial weather routing company in support of the deductions. So in order to determine whether or not a charterer's claim is valid, it's going to be necessary to consider a series of questions. These are, does the charter party give any warranties? If warranties were given, what were they, and were they subject to any conditions? If warranties were given, how do you decide if the vessel actually complied with them? And how do you then calculate any underperformance or overconsumption? And finally, are there any other ways of establishing a performance claim under the charter party? I'm going to be talking about the first two, then I'm going to hand you over to Alex Smith, who will talk about the second two. Could I have the next slide, please? Now, there's often a misunderstanding about the basis for any underperformance claim, and the commercial view of what certain clauses mean and what constitutes a valid claim is not the same as the approach taken in English case law. The starting point in any potential claim for underperformance is to consider whether the charter party gives any warranty about the vessel's capabilities. If there's no warranty in the first place, then there can be no breach of warranty and so no claim. Now, the key issue will be, what does the charter party actually say? And where there are questions about the construction or interpretation of any term, tribunal or court will ask itself, what did the parties intend this provision to mean at the time they entered into the charter? And you'll see that I've put there on the slide a reference to a quote from Mr. Justice Hobhouse in the leading case of the Didymi, in which he made it clear that the words of the contract are used objectively to state the intention of the parties to the contract. They may do so skillfully or clumsily, but the function of the court is to extract from the words used their objective intention. So it is worth checking the whole charter for relevant terms, check different places for what the parties have said, as you may find warranties appear in several different places. Fixture recap, particular description clauses, which may sometimes be attachments provided separately and then incorporated, riders, questionnaires, and proformas. So if there is any conflict between the various terms, the normal rules on construction of contracts under English law takes effect, and specially agreed or negotiated clauses will take precedence over standard printed clauses. And this will usually mean, for example, that provisions in a fixture recap will take precedence over terms in a pro forma. But all provisions are assumed to mean something, so a court or tribunal will often find a way to give effect to them all if possible. Can I have the next slide, please? So the question is, have owners agreed any performance capability for the vessel? Were any warranties given? So here on the slide, you can see the NYPE clause as a simple example of a performance warranty. In this case, it says the vessel is capable of steaming fully laden under good weather conditions, about 13 knots on a consumption of about 29 metric tons of IFO. So you can see from that description that the vessel owners have made representations about the vessel's speed capability and her fuel consumption. And I've put also on the slide just another example from a vessel description in a fixture recap to give you some idea of where these warranties often appear. It's worth bearing in mind that speed and consumption values do not exist in isolation, and that ordering the vessel to go to higher speed will result in a higher fuel consumption. So you'll sometimes see a range of warranties given, and it's therefore something of a balancing act as a charterer in deciding whether speed is of the essence, possibly resulting in a higher fuel bill, or whether the cost of bunkers is paramount so that a lower speed is ordered, which may result in a slightly longer time on hire. What if the descriptions given without guarantee? What is the effect of such a provision? Well, the effect is that rather than making it a warranty, it simply makes it an estimate or a representation, and that was held to be the case in the LEPA. It is just a representation, not a warranty. Again, it's worth checking all parts of the charter party if you do come across a reference to without guarantee, as it may be that the main body of the charter party doesn't state that the speed and consumption values are given without guarantee, but the fixture recap does, or vice versa. So if that's the case, you'll need to consider which terms take precedence using the normal rules of construction that we've just discussed. So a good example of this is the decision in London Arbitration 5 of 2006, where it was held that the acronym that you see on the slide there, which is short for all details about without guarantee, which was shown at the bottom of a description clause in a fixture recap, was enough to qualify all the statements preceding it as being without guarantee, and the result being that the charterers could not bring a claim for underperformance. Can I have the next slide, please? So if warranties were given, what were they? Were they subject to any conditions? Now, it's unlikely that an owner would warrant a vessel's performance capabilities in any and all conditions, and normally you find that the warranty is given in good weather conditions. You may have to look further into a charter party to find a definition of this. Often there's a separate clause describing the conditions which count as good weather, and you will usually find that they are defined as periods where the wind is no more than Beaufort Force 4 and sea state is no more than Douglas Scale 3. It isn't always the case, however, that there's an express reference to good weather, and you do need to check the terms of the charter party. And for example, the Shell Time 4 doesn't use that term and instead provides a different way of dealing with adverse weather periods. Usually there'll also be a reference to all details about. Sometimes an express definition of about will also be given, either in the fixture recap or the description clause. But where there's no express definition, a tribunal will normally apply a margin of 0.5 knots and plus or minus 5% for bunkers. However, it may not always be appropriate as the right margin, and it's a general rule of thumb only. It is not sacrosanct, which is what the judge in the case of the Albeda said. Does the reference to about qualify both speed and consumption? Well, it partly depends on what it's, and this particular issue was considered by a tribunal recently in London Arbitration 21 of 2018. Now, in that case, owners were claiming that a provision saying that the vessel would achieve about a speed of 14 knots on about a fuel consumption of 26 tonnes of IFO entitled them to a double benefit for the two abouts. And the clause actually went on to say that the speed and consumption warranties were with a tolerance of 5% about. And the tribunal held in that case that where the clause in question had a double about, that made it clear enough that owners got an about adjustment on both figures. Could I have the next slide, please? Discussing conditions further, it's common to see performance warranties refer to the Douglas scale or sea state, but this can give rise to problems of interpretation, as there's no universally agreed or internationally recognised definition of Douglas sea state. It's also common to see references to average wave heights and significant wave heights. Now, it's worth mentioning here that wave height did not form part of the original Douglas sea scale. The WMO does now, however, assign an average wave height to sea state 3 of 0.5 to 1.25 meters, and I've put the reference there on the slide, and it's generally accepted that Douglas scale 3 refers to local wind-driven waves with an average height of that particular range, 0.5 to 1.25 meters. Now, significant wave height is not really very well understood. It's actually a measure of the average height of the highest 1/3 of a population of waves, measuring the wave from trough to crest, that occur in any given period. And this will always therefore be a higher number than the measure of the average height of all the waves. London Arbitration 12 of 2014 did look at this particular issue, and in that case they held that Douglas Sea State 3 corresponded to a significant wave height of 2 meters. That was based on the method by which one of the weather routing companies determined good periods. The decision was based on some published articles, however, and it is now generally considered to be the correct equivalent. Could I have the next slide, please? Problems can, however, arise, and we see this fairly frequently, where the charter party refers to the Douglas scale and to wave height, and questions can sometimes emerge if it's not clear whether these are to average wave heights or significant wave heights. And you will often see conflicting provisions which might refer to Douglas Sea State 3 and a significant wave height not exceeding 1.25 meters. And they sometimes appear in the same clause, and as we've seen, the two do not necessarily correlate. London Arbitration number 6 of 2019, fairly recently, did give some further guidance on how these questions should be approached where you have conflicting provisions. Now, in that case, the charter party, as you can see, provided that any warranty was given in good weather conditions with a wind speed of a maximum Beaufort force 4 and total combined sea and swell significant wave height confined to limits of Douglas Sea State 3, 0.5 to 1.25 meters, with no adverse currents and no influence as well. Well, as we've seen, the significant wave height for a Douglas Sea Scale 3 should not be 0.5 to 1.25, as that is a measure of average wave heights. So the charters in that case said that significant wave height of 2 meters should apply, relying on London Arbitration 1214, even though there was no mention of 2 meters in the terms of the charter party. The owner said that under the terms of the charter, the highest allowable wave height was 1.25 meters. Now, the tribunal, having to grapple with this, came to the following conclusion. And I'm just going to quote here what they said in this case. They said, good weather conditions extended to significant wave heights of no more than 1.25 meters. In reaching that conclusion, the tribunal had sought to give effect to as much of the language used as possible and to reflect the clear intention of the parties to take account both of sea swell in the calculation of significant wave height and avoid the adoption of a significant wave height of 2 meters, of which no reference at all was made in the recap. So the tribunal appreciated that in doing so, it was in a sense treating the reference to Douglas Sea State 3 as surplus, and it was thereby limiting consideration of the vessel's performance to lesser conditions than might often be the case. So the result was that based on that decision, which of course is not necessarily binding, but it is informative, that if a charter party contains conflicting provisions regarding height of combined wind waves and swell, the tribunal is likely to give effect to specific heights if these are referred to in the clause, and will effectively ignore the reference to Douglas Sea State 3 if that does not fit with those specific words. Could I have the next slide, please? Currents, treatment of currents. Treatment of currents can raise a number of issues when considering claims. Some charter parties mention ocean currents, and some charter parties are entirely silent about currents when it comes to performance. So do currents form part of the good weather definition, or are they simply a contractual limitation on evidence in assessing the vessel's performance? It's a common problem, and we come across arguments quite frequently that any periods where there have been adverse currents should not be taken into account when determining whether a period of good weather. But it is always a question of looking at the words that are used and trying to interpret what the intention of the parties was. And I've just, as by way of example, put a couple of examples on the slide there so that you can see the slightly different wordings that are used. It always comes down to a matter of construction of the words that the parties have used, whether or not they will be part of the good weather definition, or whether you simply take account of currents when you're then assessing a performance speed for the vessel. Could I have the next slide, please? What happens when the charter party says nothing about currents? Should an allowance be made for them? Could I just go back to the previous slide, please? Where the charter party says nothing at all about currents, the position is actually unclear. There are a number of conflicting and confusing arbitration decisions. For example, London Arbitration 21 of 2004 took the view that unless the parties specifically mentioned currents, the tribunal should simply ignore them. London Arbitration 15 of 2005, however, took the view that ocean currents are a fact of life and to ignore them would be illogical. What about when a charter party says not against adverse currents? Should periods of adverse currents be left out of account altogether, or should an allowance be made for the effect of those currents? And as we mentioned above, it's essentially a question of construction, and it comes back to the points we made earlier about how and where currents should be dealt with. If the relevant clause is expressed in such a way that it imposes a limitation on the period which can be used to assess the vessel's performance, the charterers will have to try to find periods during the voyage when the weather is good and the current is not adverse. But it may just be that it is simply a matter instead of using them to determine what the vessel's performance speed actually was. But the point, I think, is that where there is a reference to not against adverse currents, they do need to be considered when you're looking at any performance claim. Can we go to the next slide, please? What happens if the charter party says nothing about favourable currents? Should they be taken into account? Now, the answer has varied over the years, with a couple of London arbitrations giving conflicting decisions, in particular those number 15 of 2007 and number 4 of 2012. You'll see that London Arbitration 15/7 had decided that they would be excluded, but the tribunal in 412 had some difficulty in following the reason and actually doubted whether it could be right, even on the wording in that clause. So it was actually quite welcome that there's been some more recent guidance in London arbitration, and the decision of the tribunal in 21 of 2018 set out what it thought was the correct position. And I've set out there the relevant part of the decision. It said the parties had agreed in clause 29 only to exclude adverse currents from consideration of the vessel's performance without any mention of favourable ones. The owners were therefore correct in saying that the reference to the exclusion of periods or negative or adverse conditions was a concession to them. Other periods, including ones of favourable current, all form part of the conditions in which the vessel's performance was to be assessed for compliance with the warranty. So unless the effect of that is that unless the charter party says otherwise, owners take the benefit of favourable currents. And some charter parties you will find now expressly provide for how favourable currents are to be approached. And you can see the charter party that was considered in London Arbitration 22 of 2018, which was an example where positive currents were expressly dealt with, although the decision didn't turn on that aspect. You can see that the conditions specifically say that owners are to have the benefit of positive currents. Could I have the next slide, please? So on this slide, I've simply summarised the position as far as it is at the moment. If there is no mention at all of currents, the position is unclear, unfortunately. When it comes to adverse currents being mentioned, you need to consider whether or not these actually form part of the defined period when performance is assessed in the first place, or whether you simply make an allowance to a performance speed by use of a current factor, which is what a number of weather routing companies often do. As to favourable currents, if the charter party is silent, the owner will take the benefit, and it's not appropriate to make an adjustment to any calculation of good weather speed. The decision in London Arbitration 21 of 2018 makes that quite clear. I'm now going to hand over to Alex, who's going to begin by discussing how to calculate performance claims according to English law.
Thank you, Pamela. So Pamela has explained how to identify whether a charter party contains any performance warranties and whether those warranties are subject to any conditions. But how should the parties determine whether there has been a breach of a performance warranty? And if there has, how should they calculate the extent of the vessel's underperformance in terms of the time lost and the bunkers overconsumed, which will, of course, inform the quantum of any claim that the charterers may have. The first step should always be to consider the terms of the contract, which may state expressly, to a greater or lesser extent, on what basis the vessel's performance is to be calculated. Generally speaking, under English law, commercial parties have the freedom to contract on whatever terms they wish. So if the contract states in clear words upon what basis or part basis a vessel's performance is to be calculated, this will normally be binding upon the parties. However, when approaching a performance calculation, there are essentially three elements to consider. Sorry, could I have the next slide, please? The first of those points is what sources of weather data should be used. Secondly, does the Didymi principle apply, and should I extrapolate the performance during good weather? And thirdly, what method of calculation or formula to use? Could I have the next slide, please? So there will normally be two main sources of weather data. The vessel's deck logbook, which will contain weather observations from the officer of the watch, and B, any weather routing report. A weather routing company will often be engaged by the charterers to provide forecast and real-time weather data to the master to assist with passage planning. Each of these two sources of data, the logs and the weather routing report, can have their own benefits and drawbacks from an evidential perspective. And where there is a discrepancy between the two, arguments can usually be made either way as to which more accurately reflects the true weather conditions experienced by the vessel. Weather routing companies use various sources of their own, such as satellite data and computer modelling, to determine weather conditions, and the results can differ significantly from those conditions actually experienced by the relevant vessel. On the other hand, the observations recorded in the deck log ought to reflect the conditions experienced by the vessel, but they can be inaccurate, particularly in relation to sea state. However, often the charter party will expressly state what is to happen where there is a discrepancy between the deck logs and the weather routing data, and if it does, that will be binding upon the parties. And could I have the next slide, please? So where a charter party does state that data provided by a weather routing company shall be binding, it is important to distinguish between the raw weather data and any analysis or calculations provided by the weather routing company in their report. So in London Arbitration 2104, Tribunal considered the meaning of a clause which provided that vessels shall be capable at all times during the currency of the charter party of steaming at about 13 knots ballast laden. For the purpose of the charter party, good weather conditions are to be defined as weather conditions in wind speeds, including but not exceeding Beaufort force 4. In the event of a dispute over the apparent performance, data supplied by Ocean Routes, that's the weather routing company, shall be taken to be binding upon both parties. So the tribunal held that only the raw data provided by Ocean Routes was binding upon the parties, not Ocean Routes' finding as to the vessel's performance. So some charter parties do, however, provide with clear words that the analysis of charterers' weather routing company will be binding, or perhaps more commonly that a third party, such as an expert or second independent weather routing company, should be appointed to determine the vessel's underperformance. There can nevertheless be difficulties where a charter party provides for the appointment of a third party, but the relevant clause is unclear as to the precise role of that third party. For instance, where parties agree to appoint an expert to determine the vessel's performance in good weather, but cannot agree in the first place what good weather means. So if I could have the next slide, please. So, as I've said, one must always check what, if anything, the charter party says in relation to the vessel's performance, in relation to how the vessel's performance must be calculated. But there are two important authorities which set out the default position. And the first of these is the Didymi, where Mr. Justice Hobhouse had to consider how to assess a vessel's performance over a 5-year period in circumstances where the performance specified in the vessel's description was made by reference to good weather. He decided that the starting point was to find those periods when the weather was good, as defined in the description clause. If the vessel was found to have underperformed in good conditions, then it would also logically have underperformed in bad conditions. And so he found that once the breach of guarantee has been established by reference to performance in good conditions, the loss is capable of being proved in all conditions. And this reasoning was then approved by the Court of Appeal in the gas enterprise, where Lord Justice Lloyd said, once the speed of which the vessel was capable in fair weather has been established for each passage, the warranty takes effect. If the speed is less than the warranted speed, or if the consumption of the bunkers is greater than the warranted consumption for that speed, the charterers are entitled to recover compensation over the whole passage in question, not just that part of the passage which was performed in good weather. So essentially, therefore, the default position approved by the English courts is that the good weather periods must be found, the weather's performance in good weather should be established from these, and the level of any underperformance during the good weather periods must then be applied or extrapolated across the whole of the voyage. So by way of example, you might have a 30-day voyage with only 48 hours of good weather. The Didymi approach would be to calculate the extent to which the vessel underperformed in terms of speed and consumption during that 48 hours of good weather, and then to extrapolate that degree of underperformance to the remaining 28 days. And I've said that is the default position because, as is normally the case with English law, English contract law, I should say, parties are free to contract out of the Didymi principle if they wish, but to do so would require clear and unambiguous wording in the contract. Could I have the next slide, please? So, in terms of how to calculate the underperformance, sometimes the speed and consumption provisions within a charter party will prescribe a method for calculating the vessel's performance in terms of time lost and bunkers overconsumed. I have seen clauses which actually set out a formula to be applied. In these circumstances, one should follow the approach specified by the charter party. But in the absence of a method expressly provided for in the charter party, there are a number of different methods that can be used. The important thing is to ensure that the approach that is taken reflects the Didymi principle, unless this has been contracted out of, or reflects the terms of the charter party. And this is a really important point because it's relatively common for parties to instruct weather routing companies to provide a report addressing not only the weather conditions experienced by the vessel on a given voyage, but to actually analyse the vessel's performance. The methods used differ between weather routing companies and are usually perfectly valid in themselves, but particularly as the weather routing company will not usually have seen the charter party, often the method used will not comply fully with the terms of the charter party or with the Didymi principle, which, as I said, has been approved by the court. So on the slides, I've set out one of the methods for calculating a vessel's performance in terms of time lost, and one for calculating over or under consumption. These aren't the only possible methods to comply with the Didymi principle, but they do comply with it. So for time lost, you'd firstly calculate the good weather performance speed in knots. Do that by taking the good weather miles and dividing that by the good weather time, so the number of hours of good weather you experienced on that particular passage. Then work out the hours the vessel would have taken to complete the whole voyage in good weather. So you take the total distance of the whole voyage, divide that by the good weather speed, so the actual performance speed achieved by the vessel during good weather, and then take the time the vessel should have taken in good weather. So that's the total distance of the whole voyage divided by the warranted speed in knots. And if you subtract the time that the vessel should have taken in good weather for the time from the time that it would have taken to complete the whole voyage at its good weather performance speed, you then have the number of hours lost. If I could have the next slide, please. So as you can see there, I've set out some calculations just using that same formula. These slides will be available in a couple of days, I think, on the website. So if you want to refer to that, you can do. Next slide, please. Bunker consumption is a little bit more complicated to calculate. One method is to compare the notional values of what the vessel would have consumed if the voyage had been performed entirely in good weather, with what the vessel should have consumed if the vessel had been performed entirely in good weather. So I've put the relevant formula on the slide. And you should be able to just plug in the numbers, and it will give you a figure in metric tons by which the vessel was overconsumed. If you get a negative figure, that means that the vessel will have underconsumed. Next slide, please. So just to touch briefly on underperformance claims by other names, this I mean, really could be a talk in itself. So I'm sort of giving you the abbreviated version. But if performance warranties have been given in a charter party, that is, if the level of performance described in the vessel description clause is not qualified by the words without guarantee, and where such warranties are ongoing, the most straightforward cause of action will often simply be for breach of those performance warranties and for damages. However, where the vessel description clause is qualified without guarantee, or where the performance warranties are not ongoing, or where they're subject to very restrictive good weather or other parameters, charterers can often try to formulate an underperformance claim upon some other charter party provision, and the most commonly pleaded one that we've seen is off hire. So for instance, you can try and bring the claim within the second part of clause 15 NYPE, which in its unamended form provides that if upon a voyage the speed be reduced by defect or breakdown of any part of the hull, machinery or equipment, the time so lost and the cost of any extra fuel consumed in consequence thereof, and all extra expenses shall be deducted from hire. So one benefit from the claimant charterer's perspective of bringing an underperformance claim as off hire is that, unlike with a damages claim, credit does not need to be given for underconsumption caused by reason of the vessel's reduced speed. It's not uncommon to see speed and consumption claims where the alleged cause of the vessel not performing, as described, is poor fuel combustion in the main engine, which can result from poor maintenance. In circumstances where this can be evidenced sufficiently, it's likely that clause 15 will be engaged. Another cause of underperformance is hull fouling. There is judicial authority in the form of the Joanna that the hull fouling on delivery can constitute a defect in the hull, such to engage an off-hire clause. However, the vessel's hull, if the vessel's hull has become fouled as a consequence of following charterer's orders, the decision of the commercial court in the Rhine suggests that this will not be a defect for the purposes of off-hire. And this is in contrast to the position in relation to a damages claim for breach of a continuing performance warranty. In that regard, in the Coral Seas, the commercial court held that where a vessel has underperformed, it is not a defence to a claim on a continuing performance warranty for the owners to prove that the underperformance resulted from compliance with the time charterer's orders, unless the underperformance was caused by a risk which owners had not contractually assumed. So the charter party in that case had been intended to be performed within the tropical range, and as such, the owners had agreed to bear the risk that there would be an accumulation of hull fouling during the charter party period. But the key thing to take away is there's a difference between a damages claim and an off-hire claim in relation to hull fouling. So next slide, please. In the Pearl Sea, the court upheld an arbitral award by which it was found, among other things, that there had been a breach of clause 8 NYPE, a failure to prosecute a voyage with utmost dispatch. Those were in circumstances where the master had deliberately seemed at a reduced speed, and that the charterers brought their claim under clause 8 because the relevant charter party did not contain ongoing performance warranties. Performance warranties themselves only applied on delivery. And the tribunal whose decision the court upheld found that even though the performance warranties applied only on delivery, the benchmark or yardstick for determining whether there had been any loss of time or overconsumption of the bunkers as a consequence of failure to proceed at utmost dispatch was still the vessel description upon which the performance warranties were based. So as such, the charterers were able to bring a claim for failure to proceed at utmost dispatch in the same amount as would have been possible under the performance warranties if those had been ongoing. We have often seen underperformance claims being brought for breach of owners' delivery obligations and or for breach of their maintenance obligations. Where the performance warranties given in the charter party apply only on delivery, charterers may try to get around this by pleading a breach of owners' maintenance obligations. In our experience, this can sometimes work, but of course, owners' maintenance obligations are usually only ones of due diligence. Next slide, please. As already mentioned, another reason why charterers may prefer to frame their claim as one for breach of owners' delivery or maintenance obligations, as opposed to simply bringing the claim under the performance warranties, is to try and get around the restrictive definition of good weather in some warranties. Therefore, for any underperformance claims that are not expressed to be for breach of performance warranties, the issue is whether such claims should be assessed in the same way as a claim for underperformance, as a claim for under the performance warranties, or whether some other mechanism can be used to quantify the claim so as to bypass the restrictions on the warranties. Unfortunately, there is no published case law directly on this point. There have, however, been a number of unpublished decisions where the issue has been considered. And as I said, if I was to go through all those, it would probably be a separate talk. But the starting point is that owners' obligations in respect of the vessel's performance are set out in the description clause. Any claim relating to the vessel's performance, however formulated, must therefore refer to the level of performance to which the owners committed under the charter party, and any restrictions to the charter party description, wind speed, sea state, currents, etc., must therefore apply to a claim for off-hire or breach of charter in exactly the same way as they should apply to a claim for breach of the performance warranties. So therefore, if you are ever faced with an underperformance claim that has been framed without reference to the vessel description, perhaps in order to make the claim appear bigger than it otherwise would be, you will usually have a good argument that the vessel's performance must be measured by reference to the charter party description, regardless of whether the claim is expressed to be one for breach of performance warranties or of some other provision. So that's all I was going to say today, but I can see that we've had a number of questions come in. So just to address perhaps a couple of those. So I've got one got one here. So how is a claim for underperformance assessed for steaming time in adverse weather conditions? And so I hope that we've already partially answered this question in that following the Didymi and the gas enterprise, where a vessel experiences both good weather, as defined in the charter party, and bad weather during a given voyage, the correct approach, subject to the terms of the charter party, is to calculate the margin by which the vessel has underperformed during the periods of good weather, and then to extrapolate this degree of underperformance across the whole voyage. However, I think what is being asked really is what happens if there just isn't any good weather at all, or there has been only very minimal good weather. And we had a case a few years ago, a reported decision called the Ocean Virgo, where clients successfully appealed against an arbitrator's findings that for a period of good weather to be admissible, it had to last at least 24 hours, noon to noon. And in that case, the judge, and it was Mr. Justice Tier, accepted that in order to be taken into consideration, a period of good weather had to be of a sufficient sample size, but he remitted the question of what constitutes a sufficient sample size to the arbitrator. So there is no clear authority regarding how long a period of good weather needs to last in order for it to constitute a representative sample, but it would appear that it can be less than 24 hours. I've recently argued on the advice of a master mariner that any one period of 8 to 12 hours would be sufficient to assess a vessel's capabilities. Sea trials upon which performance warranties are usually based are usually, are quite often very short. So it follows that unless a charter is very short, for instance, a TCT, is relatively uncommon for there to be no good weather at all. In the Ocean Virgo, which was a TCT, the judge held that the level of underperformance experienced during the ballast leg could be extrapolated to the laden leg, and that arguably opens the door to extrapolation between voyages in circumstances where good weather is encountered on some voyages during a charter period, but not on others. But still, what one might ask, what happens if there really isn't any good weather, and there is no binding precedent directly on that point. But well, so it would be open to a tribunal to find that there was no good weather, as there was no good weather, there can be no claim. But I think many tribunals may find that to be an unattractive option, particularly if, notwithstanding that there was no good weather, it's fairly obvious that the vessel did underperform, and so I think in the gas enterprise, the Court of Appeal came quite close to answering the question, but didn't actually answer it. And Lord Justice Lloyd seemed to suggest that it would, at least in principle, be open to the charterers to prove a breach of warranty by some other means. Other than by reference to good weather performance, and that perhaps suggests that any barrier to bringing to proving an underperformance claim by other means could be an evidential one rather than a legal one. And on that note, in some circumstances, and depending on the facts, it might be possible for charterers to discharge that evidential burden by reference to the vessel's performance during a preceding or subsequent fixture, and it may be possible for the charterers to obtain a disclosure order from a tribunal to enable them to do that. So I hope that addresses that question. I think we've got a couple more. I think Pamela was maybe going to address one of them.
Yes, I've got one here. We had a question about whether or not deduction of hire was acceptable when you have an underperformance claim which is disputed but seems to be valid. And I think the answer is that, as with any deduction from hire, you need to consider carefully whether it's permitted in the first place, which may partly depend on the terms of the charter party. Alex, had on his slide reference to the NYPE form, which showed there was an express right to deduct for time lost and extra fuel consumed for breach of a speed warranty. And there's some legal authority that suggests that those sort of entitlements would be of little value if a deduction was made, if that deduction was made in good faith and it was a reasonable assessment. There would be little value if it couldn't be relied on if by error the deductions were too large. So that there may be a right within the charter party to deduct, and you will also need to think about whether or not there is a claim for damages which are permitted under the doctrine of equitable set-off, which applies to hire under a time charter. It's quite narrow. It has to be situations where a charterer has been deprived of the use of the ship or prejudiced in his use of the ship. So in those circumstances, there is legal authorities which suggest that those sort of are acted on the basis of equitable set-off, but it's always going to be a question of the assessment was honest and reasonable and made in good faith. We've had a couple of other questions in about whether or not whether good weather is defined as having no adverse current, and a small period of adverse current occurs during a day, such that the overall impact of the current remains favourable and under good weather. Does that occurrence mean the whole day has to be considered as bad weather? Well, it will in part depend upon what the charter party actually says. You do find some charters which specifically refer to good weather days being a period of 24 hours, in which case you have to follow what the charter says. Most do not. And as Alex has mentioned, the question of what is a sufficient size of good weather has been looked at, and it doesn't necessarily need to be a day. You often find a problem as well that some weather routing companies tend to take more readings throughout the day, whereas some just provide a day. So it may be a question of construction of what the actual charter party says, and it may also be a question of what evidence you have as to what the weather was like at the time and what the current was like in any particular time. So I hope those have answered the questions. I think the slides are going to be available at a later time. This talk has also been recorded and that's going to be made available. So I'm just going to take the opportunity to say to everybody, thank you very much for your time and attention today. If you have any particular questions that you would like answered, please feel free to send them to us. And otherwise, we look forward to seeing everybody on our next webinar, which I understand is coming up on the 29th of June and is going to be about bills of lading under time charters. Thank you very much.
Thank you.